Hi, this is Donna Byrne, and this is Estate and Gift Tax Module 8C. We're just going over some problems about Section 2041. Okay, we've been talking about powers of appointment, and we've been talking about Section 2041 of the Internal Revenue Code. When you've finished this set of materials, you should be able to identify general powers of appointment, and you should be able to identify situations in which the exercise of the power means that the property is included in the gross estate. Okay, page 375. Peter establishes an irrevocable trust with Friendly National Bank as trustee, and the trustee has to distribute income to Anne for her life and at her death to distribute trust property to Anne's issue. So to A for life and then to A's issue. Anne has the right to ask the trustee to distribute corpus to her or her issue at any time and for any purpose. Now she dies without exercising the power. So what tax consequences? Well, first of all, does Anne have a general power of appointment? Oh, here's another important question. When was the power created? So let's just sort of usefully assume that all powers were created after 1924, unless explicitly indicated otherwise, which it won't be. Okay, so now we can ask, was it a general power of appointment? Well, yes, because Anne could distribute corpus to herself. And since this is a general power of appointment, Section 2041 includes the value of the trust corpus in Anne's estate. Part B. Let's say instead, Anne can appoint the trust property in her will to any person. Okay, so before she could demand it at any time, and now only in her will. So in other words, she can't really appoint it to herself, because she'll be dead by the time her will actually is effective. And she can't appoint to her creditors, but she can appoint to any person in her will. Okay, it doesn't matter that she can't appoint to herself or her creditors, because she can appoint the property to her estate or to creditors of her estate. And that makes this a general power of appointment, and we include the trust property in her estate. What if she can appoint the trust property in her will, but only among her issue? Okay, now she's out, her creditors are out, and now she can no longer appoint to her estate or the creditors of her estate. So once again, now this time, this is not a general power of appointment. Okay, are you clear why? It's not because this is a testamentary power. It's because she can't appoint to any of those four suspect categories: self, creditors, estate, creditors of estate. Okay, what if she can appoint the trust property in her will, but only among her issue, same as before, but she had borrowed money from her daughter Ellen. So in other words, one of her issue is also her creditor. That doesn't really matter. So Ellen's wearing an extra hat. She's only a permissible appointee because she's issue, not because she's a creditor. So this is still a non-general power of appointment, and we don't include anything in Anne's estate. Okay, what if Anne can appoint the trust property in her will, but only among her issue, same as we've been working with, and if she does not appoint the property, the trust property, it passes to her executor, in other words, to her estate. Ah, well, if the taker in default is Anne's estate, then she effectively chooses her estate if she decides not to exercise the power. And this is a consistent way of viewing non-exercise. Anytime we don't exercise a power, anytime we allow a power to lapse, anytime we release a power, we're still making a choice. Because that choice is her estate, this is probably a general power of appointment. This might depend on the jurisdiction, but probably this is a general power of appointment. I know, it seems weird, doesn't it? Okay, let's go on to problem 2. Penny establishes a testamentary trust by leaving money to Ben, her son, as trustee, to pay income to Ellen for life, and at her death to distribute the trust property to Fred. As the trustee, Ben has the right to manage the trust property and invest it. What are the estate tax consequences for Ben when he dies and is still serving as trustee? Not a problem. Management powers are not a general power of appointment. He can't take the property for himself or his creditors. And the regs are clear in case we were fuzzy. And just as an aside, same rule applies for Section 2036 and 2038. I think we've seen that before, that just management powers are not a problem for us. What if Ben, as trustee, has the right to accumulate income or to distribute it among Penny's children and grandchildren? Careful. This doesn't look like a general power of appointment because it limits the class of people that he can appoint to, but Ben is one of Penny's children. So the right to accumulate income and distribute it to Penny's children means he can distribute it to himself. So this looks like a general power of appointment. There is a little glimmer of hope, though, because Ben's fiduciary obligations might mean that he cannot appoint to himself. Some courts have held that when a trustee has the right to distribute income to a class of which the trustee is a member, the trustee cannot appoint to himself, and in that case there would be no general power of appointment. But not all states have that rule. You have to check state law on this one. Okay, and here I've got two slides in the wrong order, so we'll go to this one first. There it is. Assume that the trust will terminate at Ben's death, and Ben has the right to designate which of Penny's descendants will share in the distribution of trust property at that time. Now what estate tax consequences? Ben, as we've pointed out, is one of Penny's descendants, but this is a testamentary power of appointment, which means that it only operates when Ben dies. So he's not going to be around to take at that point, which means he cannot appoint to himself or his estate or his creditors. So this is not a general power of appointment, and we do not include anything in Ben's estate. Okay, problem 3. Sally creates an irrevocable trust with Tom as trustee. And this should look familiar. Trustee is to use income and corpus for the benefit of Sally's grandson Larry until he turns 21. When Larry is 21, trustee will distribute the trust property and accumulated income to Larry. And if Larry dies before 21, the trust property will be distributed to whomever Larry appoints in his will. In the absence of an appointment by Larry, the trust property is to be distributed to his surviving siblings. This looks kind of familiar, doesn't it? This is a 2503C trust for a minor. It meets all those requirements, which means that not only is this a completed gift, it is a gift of a present interest. Now, what if Larry dies when he's age 17? He's still enjoying the benefits of this trust, and he has a general power of appointment over the remainder. We include the trust property in Larry's estate because of the power of appointment. Section 2041 will bring in the whole trust property. Did that bother you? It shouldn't, because think about it. 2503C is just the way we structure a gift to a minor. If Larry weren't a minor, we would have been giving him this property outright to begin with. So it's kind of appropriate that it would be included in his gross estate. Now, what if the trustee Tom is Larry's father, and Tom dies, trustee dies, when Larry is 15 and still enjoying this trust? Well, Tom had the power to use income and corpus for Larry's benefit. Tom also had an obligation to support Larry because he's Larry's parent. So that means that Tom could use the trust property to pay some of his own creditors. Tom has a general power of appointment, and we can include the trust property in Tom's gross estate under Section 2041. Whoa! That's cool. If Larry dies, we include the trust property in his estate, And if Tom dies, we include the property in his estate, and it's because of the same code section. That's okay. Don't let that bother you. We have other situations where there are two people who either one, if they die first, would mean that we include the trust property in their estate. Right? Think about joint tenancy property. Don't let it bother you that we could be including trust property in different estates. Okay, last one, problem 4. This is kind of an interesting situation. Someone creates an irrevocable trust with a bank as trustee to pay income to Mary during her life, and then at her death to pay off any claims against her estate, and then the expenses from the funeral and estate administration, and then all the federal and state taxes. And then whatever's left goes to Mary's descendants. So basically, we're going to pay off all of Mary's debts and all of the estate expenses before we pay out anything else. Okay, do you see a power of appointment? Well, what could Mary do? All she'd have to do in order to say where this money goes is die with debts. Yeah, that's actually enough. In Albuquerque National Bank, district court said that a very similar power was a general power of appointment and included all of the trust property in the person's gross estate. Now, that case got reversed, but for a different reason. Moreover, the IRS has said in a technical advice memorandum that, hey, the decedent had the power to live well beyond her means with the knowledge that residuary trust assets could be reached at her death if she overspent the corpus of her own estate. And that means that she clearly had the power to use up that money during her life. So this is a general power of appointment, right? Even though it doesn't look like a power of appointment, if the beneficiary could spend money in such a way that it has to come out of the estate, that's like directing where it goes. Okay, that's the end of this module, just those problems, and I will see you in class. Thanks for watching.